number 44, the people of the state of New York versus Mark Mitchell. Counsel?
Good afternoon. 2 minutes for rebuttal, please, Your Honor. 2 minutes for rebuttal, please, Your
You
Honor.
may have 2 minutes.
Thank you. May it please the court, Ying Ma on behalf of the appellant Mark Mitchell. Standing in place on a public sidewalk and calling out "help the homeless" is not accosting as any English speaker understands that word.
What
And
if you block the sidewalk?
I don't think that meets the common definition of accosting, which is to approach someone, to go up to someone, meaning that you are physically in their personal space.
But what
And
if you're in their personal space that they want to be in, and the only way to get by is to approach you?
I mean, I think the gravamen of the word is that it's hard to disengage when someone is coming up to you and someone is in your personal space.
But I'm
If
walking
you-
down a Manhattan sidewalk and you block my way. How is that not approaching me?
I think it's a closer question, but I don't
And
believe
isn't that
it's...
what happened here?
In this case, Mr. Mitchell was on a public sidewalk. He had 2 milk crates set up as a makeshift table, and he was just passively making a call out for people to help the homeless. It doesn't say anything. I understand he was charged with disorderly conduct in that 75 people walked around him, but those were 75
But it says
people.
he blocked the movement of approximately 75 people by the way he set up his milk crates. And
Yeah.
that's, again, I understand it might have been in support of another charge as well, but it's in the affidavit supporting this.
And they were able to easily walk around him. They were not
But
stopped.
this
They
is,
were not...
we're looking at this as a complaint, right? It's a standard for a complaint, so whether they could easily walk around him or not, that you could maybe argue that at trial, but why isn't that enough for the complaint?
Because there's simply no non-conclusory evidentiary facts of accosting. Accosting has a common definition, which is to go up to someone and to speak to them insistently,
But
and that's simply not...
actually not the common definition, at least it wasn't at the time, right?
I mean, I think at the most we have ambiguity. At the time, respondent does cite a few selected dictionaries that say that accosting means to speak to. Respondent also cites at least one dictionary from the time, from 1961, that does define accosting as to aggressively approach. So
Well,
at
that
most,
dictionary from 1961 defines it to be to approach, to speak without having first been spoken to. That's the first definition. The second definition is yours, to confront, usually in a challenging or defensive way.
yes, and respondent is able to provide no example from common usage either back then or today in which accost is used.
Isn't a dictionary definition somewhat the definition of common usage? And every one from that time, at least as a first definition, lists the more general approach, speak to first.
I believe the case law is clear that dictionaries are merely a guidepost and that we do look to the common understanding of the word, because I think you would come across notice issues if the plain meaning of a word were so vastly out of sync with what a dictionary
And
defined
so
it to be.
why are these definitions out of sync?
Because there simply is no common usage that's given in any of respondents' arguments in which the word accost simply means to speak to first. You would never say the teacher sitting behind a desk accosted her students with a good morning class, or the bus driver.
Outside of dictionary definitions, and maybe this is a fault in my own education or something, I don't know what the common definition of accost is. I use the word, no question about it, but I never really gave deep consideration to what it was. And if I wanted to know, and lately I have wanted to know, I would go look in a dictionary. So what are the sources of common understanding, as you put it, that exist outside of the dictionary?
Well, I believe we cited numerous common usages from the New York Times, from novels, from other literary sources, and I think it's very telling that respondent could not find a single example from any source outside of the select dictionary from the 1960s that does define accost as to speak to. And I do want to point out that this is not even the definition that the appellate term first department used in this case. Their definition is completely nebulous, it's not rooted in any dictionary. Their definition is to take some affirmative action to make contact with the victim. and you won't find that in any dictionary because that's just not how anyone uses that word.
And just to be clear, your assertion with respect to the common definition is an approach accompanied by some aggressive verbal exchange? Is that right?
Yes, I think an approach followed by speaking to someone specific in an insistent manner. I think that is entirely consistent with how it's commonly used, and
Well, insistence a little different than, I think I heard Judge Garcia use the word defensive and/or aggressive. I think he might have said that. You know, there's certainly a difference between the tenor of those words. So which is it? Is it just insistent? Is it like, oh, please give me money? Or is it, hey, give me money, or, you know,
I
I'm
mean,
going to hurt you?
I think there are a number of ways that you can accost someone. You can either do it through a persistent interaction, like sort of not letting someone disengage by continually asking them for something, or you can do it in a more confrontational manner. But I think what matters is, in this case, Mr. Mitchell didn't do any of those things. He was merely standing on the sidewalk, making a call out to the general public, not to any specific person. And in fact, 75 people were seen just freely walking past him. Nobody felt any
But
type
those
of pressure.
75 people had to redirect their passageway based on his putting the crates in the manner that he did.
I mean, that may be, but that's just a fact of urban life. Often the Girl Scouts set up tables and people have to walk around them if they don't want to buy cookies, and that's just,
So that
That would
there's
go,
a,
I'm sorry, go ahead.
so that there's a functional equivalent of an approach, that he wasn't going to approach them, but he made the traffic go in his direction.
but nobody even engaged with him, even if you think that he made a functional equivalent of an approach. Nobody engaged with him. He was not persistent or insistent in any kind of engagement.
Is-
So they
Is
would have to
anybody.
stop.
I'm sorry, is that part of a cost? Does there have to be an engagement? Does there have to be a response from the person who's being accosted?
No, there doesn't, well, I don't think there has to specifically be a response, but it has to be directed, targeted to someone. And to the extent that your honors think that there is any ambiguity here, I think the rule of lenity dictates that the interpretation most favorable to Mr. Mitchell is the one.
But you're arguing kind of an ambiguity on the facts there, it seems like, not on the law. I mean, if the law is clear what the definition is, then we don't apply the rule of lenity. But I'm having a hard time. So approach isn't enough to you. So in those examples, and some of them are in the examples of why they promulgated the statute, where it's kind of it's fraud, right? It's not a robbery, where they go up and I lost my wallet, or that's not enough because it's not persistent or aggressive. I can change your $10 bill into a 20. That's not necessarily aggressive. It might be hopeful, it might be luring, but it's not aggressive or persistent. And what if you just said that once?
I mean, I guess respectfully, I disagree. I think that is a persistent, targeted approach. And in any event, that's clearly worlds away from what Mr. Mitchell did here. Those
But it
were
doesn't
elaborate.
fit your definition, it seems like. Persistent to me means if you try to walk away, you keep after them. Aggressive obviously has its own meaning. But approach is different.
I mean, I think in those two examples, there was definitely an approach. And I think by the nature of what they were saying, kind of like, oh, come look at my handkerchief, it can do this, magical
That's
thing.
aggressive or persistent?
I think it's insistent in a way that, draws someone in. But I think the main fact is that you've entered someone's personal space such that they feel like it's somewhat difficult to now disengage with you. And in any event, I think we don't even need to.
So counsel, I'm sorry, I'm on the screen, counsel. So it sounds like you've got a version of a type of solicitation, right? That's what it sounds like you're saying in response to Judge Garcia, that there's a solicitation, right? In his case, it's here, give me money. But you're saying it has to be more than just asking for the money.
Yes, because I think.
Am I understanding you? Okay.
Yes.
So what would that be? Trying to help me understand the way you're responding to Judge Garcia, because I too am finding a little bit of difficulty understanding your dividing line between accosting and free speech.
Well, I think anything that would satisfy the statute of attempted pettit larceny by false promise.
Okay.
I mean, we already have that statute. So there's a reason that the legislature created fraudulent accosting, and that reason is,
But isn't that the mens rea? Isn't that the mens rea as opposed to the actus reus? Right? Isn't that a little bit of that?
right, but I think
That
my
you're
point is,
conflating?
yes, my point is that the First Department definition of accosting sort of melds the two statutes. There's no way that you can be guilty of fraudulent accosting under this some affirmative action definition and not also be guilty of attempted pettit larceny by false promise. The only way that this is a separate statute that has an independent actus reus is if you give meaning to the term accost, and that you don't find it to be this completely nebulous some affirmative action. Anything could meet that definition, some affirmative action. You could take a piece of paper and write on it, help the homeless, and hold it up, and that would meet the first, the
Not if you
appellate
define it
term.
as approach or call out to, right?
I'm sorry?
Not if you define accost as approach, right? Because if you're sitting on the side of the road with a sign on your table and somebody comes over and says, hey, what's that about? That's kind of but that's not what happened here.
Well, I'm sorry, maybe I'm not understanding.
Because
The
here, he
appellate
blocks
terms-
the sidewalk, people have to walk around him, and he's calling out to people saying, help the homeless, and, I mean, the second element, which I know you dispute, with an intent to defraud. So that's different to me than having a table on the side of a road somewhere or under an awning, and you have a sign and people can come up and say, hey, what's this about? That's a very different scenario. I mean, it might have been covered by the old statute, which had different language in it, but it wouldn't be covered by this.
I mean, I think that old statute is exactly what would cover the facts here. Stationing, Mr. Mitchell was simply stationed in place. He was calling out for people to help the
I think stationing would
homeless.
be my example. I set up a table off to the side, I have some literature or maybe a sign, and people come up and they say, hey, what's this about? That's stationing, right?
I don't believe that the complaint has any more facts than that, besides that 75 people
Well-
walked around him, which I think
he
means that
called
they...
out.
But
I'm sorry?
He called out to them, right?
Yes, he called out to them, but
As
that's
they had
still,
to walk
that's
around
not an
them.
approach as people who use the word accosting understand that to mean.
Thank you, counsel. Counsel?
May it please the court, I'm Philip Tisney for the respondent. The fraudulent accosting statute does not require an element of aggression. The relevant dictionaries,
So counsel, I'm on the screen, counsel, if I can. Good afternoon. So if I stand in front of the courthouse on the steps and someone is trying to enter and they have to walk around me, did I accost them?
I don't think so, Your Honor. I think that's
Why not?
because you haven't taken some affirmative action to draw them into your scheme, and that's the appellate terms definition. That's the definition we're talking about here.
So if I was on a cell phone and I'm talking, that's just talking in the air, right? That's not drawing them in. Is that your point also to that? It's not just that I'm standing there without saying anything.
Also not fraudulent accosting. Talking
Okay,
on the phone.
so it has to be that I've said something at the person who's coming at me?
You have to say something that is designed or calculated to draw somebody into the scam that you have set up. You can do that through a verbal exchange, or you can do that by going up to somebody. But at no point does it need to be aggressive or persistent. That is something that doesn't appear.
How about,
in-
how about by a sign?
A sign probably would not be enough.
No, so
And I think-
why not?
Well, because the
What if the sign is really alluring? The sign is more eloquent than I am.
Sure, and that would be a situation not unlike, for instance, displaying a bunch of fake Hard Rock shirts and allowing people to be drawn in by the shirts. What the statute contemplates is an affirmative action by the defendant himself. That's what we're looking at when we're talking about a cause. You either have to address somebody or you have to approach somebody to address them. That's what.
And do you have to approach a particular individual? Let's say 3 people are walking at me. Do I have to say it to one particular individual or make clear that I'm referring to all 3 in my attempt to draw them in?
No, because a generalized call can be calculated to produce an individual response just as much as a targeted call can be.
What if he had said, the homeless are suffering, help them?
Well, I think
Just in the air, nothing else.
I think, first of all, we're dealing with a complaint here, so all the fair inferences go to the people, but I think
Yes.
the fair instance on that is that it is inviting a donation to the fake charity. If you take out the last piece of your hypothetical, the homeless are suffering. The homeless are, you know, I don't, just the first part.
Well, I'm sorry, didn't he only say help the homeless? I may have misread the record.
No, the officer alleged that he asked passing pedestrians to, quote, help the homeless.
Right, but did he say how? Did he verbally say how to do that?
No, well, the allegation isn't in the complaint, but the allegation in the complaint is that he was asking passing pedestrians to help the homeless, and on his,
Right, but we're just talking about the accosting. So if it's what he has to say, since you said a sign is not good enough, I don't know how anything on that table is good enough. If he then has only said help the homeless, how is that? I mean, I think that's different from if I stand on the corner and I say, please give $10 to the homeless.
well, the allegation is not that he just said help the homeless. The allegation is that he asked passing pedestrians to help the homeless. And I think the fair inference from that is that he is inviting passing pedestrians to donate money to the fake charity he's held himself out as representing so that they can help the homeless. The pieces of material on his table are relevant, not to the accosting element, but to the intent to defraud.
But could it not be that the instrument is saying by his articulation of that sentence, help the homeless, that is interpreted by the officer as a request?
I don't understand your question, Your Honor, I'm sorry.
Well, I thought that you said that what the instrument does is say that he is formally asking individuals
That's the
on the
officer's
street.
allegation, that he is asking passing pedestrians.
Yes, but what I'm saying is I understood that is a conclusion that comes from his sentence, help the homeless. That he's asking people by saying help the homeless.
Exactly, and in your hypothetical, the first part, the factual statement, the homeless are in need of help, that doesn't invite a response. But once the person, the speaker adds, and please help the homeless, that is something that reasonably inferred at this stage of the litigation invites a response, and it's the kind of thing that when you broadcast to a generalized group of people, maybe you don't get the first 100 people that you say it to, but the 101st person comes over and donates money, and we know that's the case, of course, because he told the officers that's the case. He said,
Yeah,
yep.
and if he said don't help the homeless, what act is he requesting there?
Don't help the homeless. I mean, I don't think he's inviting a response from them at all. I mean, the whole point of his setup is to hold out that the impression that he is an organization that is collecting money to help.
No, I get the other part of it. The part I'm only interested. I think some very interesting questions have been raised from the bench about what this rule would be about the definition of accosting, because it strikes me that there's real concern. I'll just say for me, real concern. Where's the dividing line between free speech and what can be criminalized? So just with the actus reus.
Well, it's not just speech or advocacy. This is
Okay.
speech tailored to draw somebody into a fraud scheme. There is no protected category for fraud speech. This is something that, by virtue of the statute, he knew what he was doing was criminal. He intended to draw people into a fraud scheme.
Isn't that why they added the intent to defraud element to begin with, to get around the constitutional problem with the statute?
In 72, yes, there was an appellate term decision, and they changed the statute to add the intent element.
Yeah, but that was my point. That goes to intent. I'm just dealing with the action, the conduct itself, right? The actus reus. The accosting part.
Exactly, but there is no liability just for accosting. It's accosting with intent, and that's why.
Yes, that's the crime, but you've got to do the action, right? That's all I'm trying to get straight here.
Exactly, but liability doesn't attach until you have both elements, is what I think.
Well, criminal liability, if you accost someone, it may very well leave you open to civil liability.
It might, but that's not what we're concerned with here today.
Correct.
What we're concerned with
I
is the
wonder-
criminal
I
penalty.
wonder why this doesn't make out an attempt rather than a completed crime.
Because I don't think you could, you're talking about an attempted larceny. I don't think you could have attempted larceny without even identifying a victim, and that's what this statute allows. It's what it was designed to do. The statute was proposed in 52 because the people at the time specifically thought that attempted larceny wasn't adequate to prosecute these kinds of scams, precisely because you needed a victim for those crimes, and you often didn't have them in these situations because either people were too embarrassed because they had been swindled or because they were tourists and they'd left the jurisdiction. And so they came up with a statute that didn't require an actual victim. All it required on the behalf of the defendant was some act to sort of trigger this scam. And what we have is a cost, is somebody who goes up to somebody else, either physically approaches them or verbally approaches them with the intent to draw them into this scam. That's the definition that was fairly well understood at pretty much every material point when this statute was enacted or amended. It's the meaning of the statute that most naturally fits with the legislative history of the city's memo in 52. I think that the Bartlett Commission revision in 1965 clearly shows that there was no intent to or any kind of aggression needed. And it's also the only one that sort of aligns with the basic purpose of this statute. The purpose of the statute is to get...
So then, if I can just be clear with what appears to be the way you see this definition, since Judge Garcia had raised this hypothetical before, I'm very interested now. You would answer it. If the setup he had, his setup had been to the side where no one has to walk around him, did he accost someone when he calls out, help the homeless?
Yes.
Okay, why is that
Verbal
under...
act in that situation that constitutes the accosting. It's the verbal act that is the invitation to the scheme.
So your definition of accosting doesn't include an approach of some kind?
It certainly can. It certainly can. If he had gone out and was making some interaction with people, that I think would be enough. But it's not limited to that. And I think that's what they're trying to get, is a definition that limits this only to scams that are initiated in some very narrow way. And that's clearly what the legislature wasn't trying to do.
And what's the authority for the definition of accost that doesn't include some sort of approach? Because I think all the dictionary ones
We have
kinda
the
say that.
dictionaries, so those I think are pretty good. The dictionaries from 1949, 1951,
Yeah.
even the dictionary, the third Webster's from 1961, and then OED in 1979, and I think 1988. Those definitions all have as their primary definition either you go up to and address, or you speak to first without having first been spoken to. Those are the physical approach and the verbal approach.
Well, counsel, then what do you make of the fact that there are these other definitions? It certainly could have been that the legislature, given what your opponent says is also the way it's actually accosting is expressed otherwise, other than in dictionaries, it's not as if her version of the definition isn't found somewhere, right? Your point is, well, it's not the first one, but it is found in these dictionaries.
It's so that...
How are we to intuit that the legislature only intended, if we assume you're right, only intended that first definition,
Well,
given perhaps some of the other concerns, right? Like the nun who's on the corner asking for money.
the nun who's on the corner asking for money doesn't come within the scope of this statute because she's not trying to involve anybody in a scam. There aren't concerns about...
Well, again, that I'm asking about
If a police officer...
the
had
actus
reason to
reus, but I
suspect-
get your point. I get your point.
If a police officer had a reason to suspect that somebody who was dressed as a nun was
Yeah.
soliciting donations for a fake nunnery, then yes, that would be grounds for an approach and perhaps a charge. But we're not talking about pure advocacy. We're talking about fraudulent advocacy. So I think these concerns about notice, these concerns about fairness really are a red herring here. This is a defendant who, if he had his way, would have committed a completed larceny. He would have engaged in conduct that is criminal in the penal law in about 3 or 4 different ways. There's no question.
Counsel, you're out of time, but one of the ways, can't we tell that the legislature didn't intend the second definition is that the Bartlett Commission recommended language in 1964 that would have tracked more closely that definition?
It's precisely that, Judge Garcia, and I want to add to that only a little bit, that the Bartlett Commission proposed adding an intent to harass. Legislature said no. But before that, the statute included an intent. It either had to be accosting with an intent to disrupt the peace or accosting that occasioned a disruption of the peace. The legislature affirmatively took that out of the statute. So we have both the element of harassment and the element of disruption or disturbing the peace, which are no longer in the statute. Of course the legislature didn't want that, and that makes sense because a confidence game is a game that is built on instilling trust. It is not a game that swindles people through threats or intimidation. And if you imputed that to the statute, it would defeat the whole purpose.
Thank you, counsel.
Thank you.
Counsel, your rebuttal?
Just as to that last point, the Bartlett Commission, it's equally reasonable that they did not include an intent to harass because the word accost already, as part of its definition, has an element of aggression or confrontation, and that is exactly as its common usage
But the Bartlett
includes.
Commission didn't think that.
Well, they also didn't claim, I mean, there's no evidence in the legislative history. It's equally reasonable to assume that they believed that accosting already included
But
this
clearly the
heightened.
Bartlett Commission didn't believe that.
I'm sorry?
The Bartlett Commission didn't think it already included that because why would they have proposed it?
Oh, I understand, the commission. In any event, I do not think the legislative history or even the dictionary support the respondent's position. The majority of their own definitions include an approach, and by that, this complaint fails because Mr. Mitchell did not approach anyone. Dictionaries are, by definition, somewhat backwards looking, so the fact that it even included the definition that includes an aggressive approach, I think means that there was, at the very least, ambiguity as to the definition of the word accost back then. And when there is ambiguity, the rule of lenity dictates that the interpretation most favorable to the defendant applies, and that is because of notice issues, because we want the average person walking down the street to understand what is a criminal action and what isn't. And if everyone walking down the street believes accost to mean approaching someone with an element of aggression or persistence, and this court then uses a completely nebulous definition not rooted in any dictionary.
So, Counsel, I just want to affirm really quickly, then, under your definition, this particular 16530 really can't be used to prosecute swindles or confidence games, because as your adversary said, and it seems very true, those have to be built on trust. And if there's an element of aggression in there really isn't any possibility that there's going to be trust. So are you saying that this just can't apply to a confidence game?
I mean, I don't necessarily agree that a swindle requires trust. I think a persistent approach is what the legislature wanted to ban, because I think it is a little bit more difficult to disengage yourself from somebody who's trying to swindle you if the swindler is in your physical space, is,
So you're
being
saying it's an
confrontational.
either or, persistence or aggression?
I think there are multiple ways that you can accost someone, but the fact is that merely standing on the sidewalk and making a generalized call out, an invitation, as you will, to donate, to help the homeless, that is not accosting as anyone understands
Counsel,
that word.
hasn't that really, to get to the kind of switch the horses here, if we went with one definition or another, for at least 30 years, the courts have been defining it more broadly, not the way you define it, since at least Tanner. So the idea that people have this expectation of what accost means isn't borne out by any of the cases.
But Judge, Tanner is a criminal court decision, and they don't cite any, it's dicta,
But it's the
actually,
only
from...
cases in the record. The appellate term and the trial courts have all been applying this broader definition. I see none that applies yours. So the idea that we're going against people's expectations seems to run up against the decisions in this area.
Well, respectfully, I believe that they've been applying the definition wrong. It's not a definition found in any dictionary. They don't cite to a dictionary. It's completely dicta. The court was just merely pointing out that the defendant in Tanner had not taken any affirmative action to make contact. They weren't trying to create a completely new rule or a completely new definition of accosting, and it has been misapplied since then, and we're asking this court to fix that error based based on what the common usage of the word accost is, which is a targeted, insistent approach.
Thank you, counsel.